really interesting series of decisions that we got from the Supreme Court here, and I'm glad to see that we are reigning in the administrative state. The administrative state leads only one way. The road goes one way, you guys, and it goes to totalitarianism and communism. Welcome, everybody. Welcome to this edition of Crashes and Taxes. I am your host for the podcast, Rebecca Walser. I'm so glad to be with you guys. I obviously have been kind of on a summer break from Crashes and Taxes, but I am going to be back doing it weekly in earnest. I might be traveling while I'm doing it, but that's okay. Today, I want to cover the student loan decision of the Supreme Court in the last week, and we'll also quickly touch on their Supreme Court decision that came out on July the 4th about social media and government state action, which I think is one of the most important First Amendment cases, if not the Dr. Shiva case out of Massachusetts. So we'll talk about this. So I want to talk specifically now about the student loan decision in Biden versus Nebraska. And just know that I didn't do a slide on this because I just want to talk you through it. The slides are kind of distracting for a lot of people. And this is just more of a topic that we can discuss that's verbal and doesn't have to be slides because it's legal. It's not numbers. I like to do numbers on slides so people can really see what I'm talking about. But if it's not numbers, that's fine. So let's start off by talking about this student loan program. So first of all, you have to go back until August of 2022 when President Biden unveiled the plan, basically. A lot of people suspected that this was a kind of a play, the last minute to help the midterms go to the Democrats so that people would vote Democratic to get that I don't know why they would think they would need to, because it was an executive order. It wasn't actually done through legislation. So that was kind of dumb anyways. People would think that they needed to vote for something that was signed by executive order. But let's just talk about the plan that Biden did unveil in August of 2022. The Congressional Budget Office, and I tend to like the CBO scoring of bills. Scoring a bill means computing the cost of that bill against the budget. And you have to source and view, you have to what we call do sources and uses of all of your cash flow. But the CBO scored the bill that Biden created, or the proposal, the plan, I should say, at $400 billion. Now, the Wharton School, which is part of the University of Pennsylvania, Ivy League business school, one of the top business schools in our country, they computed that it would cost $1 trillion. So right there, we almost have we have a massive discrepancy, 1/3 to almost 3 times 3x, almost a 3x of what the Wharton basically school found that it would cost. And so what was it actually doing? It was going to basically forgive, invalidate, cancel the student loan debt of up to the amount of $20,000 for 40 million borrowers. So you could just do the simple math that and say that would be obviously closer to 800 than 400. But not everybody had the 20, so that's kind of why the CBO had a different scoring. But that is a huge discrepancy. We should not have a government watchdog or scoring like the CBO come in with something that is a lot less than what a business school is going to find. The data, we could look and see what is it that Wharton estimated how, and what is it that the administration estimated. And the CBO is always going to be on the end of using the stuff that the administration sends them. So a lot of people, this got struck down 6-3. It was what I would say be the conservative bloc, which would include the Chief Justice John Roberts and the 3 new Trump appointees, which would be Gorsuch, obviously Kavanaugh, and then his last appointee, our female. And so basically, I wanted to read to you the legal rationale of all of the Americans that are angry right now and disappointed. And even Biden, when the decision came out, basically said that the money was ready to go. Like literally they had already allocated and approved their first borrowers for their forgivenesses, and the money was ready to go to be paying off and canceling this debt. And so basically Biden said after that the decision has closed one path and now they're going to pursue another to provide student debt payment relief as they rightfully can pursue. So there's two cases. It's Biden versus Nebraska and the Department of Education versus Brown. The Biden versus Nebraska is where 6 states, Arkansas, Iowa, Kansas, Missouri, Nebraska, and South Carolina came together to sue the federal government on behalf of they don't have the ability to write something so broad in an executive order. And there was also 2 borrowers that said the department denied them the opportunity to participate in this debt relief. So Chief Roberts actually wrote, which is interesting because he can vote with the left bloc often. He has, and he's been a swing vote, and I would say he would be the new swing vote replacing Kennedy since Kennedy retired. And so what you have with Roberts is, and obviously he was joined by Clarence Thomas, Alito, and then the 3 new Gorsuch, Kavanaugh, and Amy Coney Barrett. But basically, let me just read these 3 paragraphs, because I think these 3 paragraphs are really important for you to understand kind of why it was a constitutional problem. So this is a quote from the actual ruling. Quote, last year, the Secretary of Education established the first comprehensive student loan forgiveness program invoking the Higher Education Relief Opportunities for Students Act of 2003, otherwise known as the HEROES Act, for authority to do so. So here's what's happening is the Supreme Court is writing in their opinion, here's the constitutional authority legislatively that the legislature gave in a law that then this administration picked up and wrote an executive order referencing the HEROES Act as their constitutional legal authority, granting the executive order authority to the administration. So the administration says that they're deriving their authority to reduce the student debt of many borrowers through the HEROES Act. Then the quote continues. That was all me explaining that to you. The secretary referring to the Secretary of Education from the previous paragraph, the secretary's plan canceled roughly $430 billion. Again, Wharton says it's a trillion of federal student loan balances, completely erasing the debts of 20 million borrowers and lowering the average or median amount owed by the other 23 million from $29,400 to $13,600. So basically cutting it more than in half. 6 states sued, arguing the HEROES Act does not authorize the loan cancellation plan. We agree. So right there, what you can see is that the federal Supreme Court stated that the HEROES Act that the administration was relying on as their legal support for their authority to use an executive order in the way they did, which was to pick and choose who they were going to forgive student debt based off of income, would be would be authorized. And then I will continue on. The Secretary's plan has modified the cited provisions. It's modified the HEROES statute, is what Justice Roberts is saying, is the Secretary's plan has modified the cited provisions in the statute only in the same sense that the French Revolution modified the status of French nobility. It had abolished them and supplanted them with a new regime entirely, Roberts said, paraphrasing a comment he made during oral arguments on February 28th. In other words, you can't a whole cloth write an executive order partially forgiving student loan debt if the HEROES Act itself is not explicit and giving you that authority. Therefore, the administration actually modified the law with the executive order, which is completely wrong because the law is supposed to be giving the administration the authority for the executive order. So you can't create the authority through the executive order. From a few narrowly delineated situations specified by Congress, the Secretary has expanded forgiveness to nearly every borrower in the country, the Chief Justice added. The economic and political significance of the action by the secretary who claims the authority to exercise control over a significant portion of the American economy is staggering by any measure. Practically every student borrower benefits regardless of circumstances. Now, this is where I want you to hear the whole reason that I'm even doing this podcast on this is so that you can understand what's coming and prepare yourself for what's coming, because we're going to be seeing a lot of Supreme Court decisions over the next 18 months, which would be beyond this one term, regarding a lot of things that are going to be coming down the pike. So this is a very important paragraph right here. The loan forgiveness plan would have, and this is where Roberts is quoted again, 10 times the economic impact that we have found significant in concluding that an eviction moratorium implemented by the Centers of Disease Control and Prevention triggered analysis under the major questions doctrine, Roberts wrote. Okay, that's all legalese. Let me explain it. Do you remember when the Centers for Disease Control, the CDC, basically told commercial landlords, you cannot evict people for not paying their rent? It's a moratorium against foreclosures because of the pandemic, because of coronavirus. That was decidedly, the Supreme Court already decided against the CDC, stating that the CDC did not have the authority in the statute giving them their authority to expand their authority to actually creating property moratoriums. I mean, the Center for Disease Control does not have the authority to create a property cessation of foreclosure and a moratorium on evictions. And that was something that Congress did not grant to the CDC as an executive administrative authority carrying out the laws of the land. And therefore, it needed to go back and be answered through the major questions doctrine. The major questions doctrine is how courts interpret statutes. They presume when they're looking through the major questions doctrine perspective, they're presuming that Congress is not delegating issues of major economic or political significance to executive agencies such as the Department of Education, unless it specifically says so. Unless the HEROES Act said we are delegating all student loan repayment policy and forgiveness policy to the administration. The HEROES Act would have had to say that. Unless it says that, then the major questions doctrine of reviewing statutes, and we call this, basically statutory review and statutory interpretation, which is the gray area of the law. We basically state that if some law is going to have a massive political or economic impact, then we assume through the major questions doctrine perspective that Congress would have explicitly delineated that authority, not just willy-nilly said, just do what you want. And if something has a huge economic or political impact, it has to therefore be explicitly delineated. In this case, what Chief Justice Roberts is saying here, which is what the point I want to get to for you all to understand, that the student loan forgiveness program had a 10x economic impact, even larger. It was 10 times the size as what the CDC had done with the moratorium, where the court found through the major questions doctrine, legal interpretation, statutory interpretation, that they did not have the authority under the law that they were using to grant such a moratorium. He's coming back here and he's saying that if we said that in the CDC case, this case is 10x the economic impact of that. There's no way that the HEROES Act authorizes the administration to pick and choose who is going to have their student loan forgiven and who is not. And therefore, the Supreme Court reversed the judgment of the Eastern District of Missouri, where the case was not held for the students, was held for the government, and they have remanded the case for further proceedings consistent with this opinion. In other words, it is done. Amy Coney Barrett did write a concurring opinion, and she basically states the major questions doctrine has an important role to play when courts review agency action of vast economic and political significance, citing a previous precedent. The doctrine should not be taken for more than it is. The familiar principle, would you not interpret a statute for all it is worth when a reasonable person would not read it that way? Kagan did write a 30-page dissenting opinion, and that was signed on to by Sotomayor and Jackson, which is the Kenyatta Brown Jackson. Kintaja Brown Jackson is the newest justice that has been placed on the court. So basically, the other case, the Department of Education versus Brown, Alito wrote the unanimous 9-0 decision that the borrowers did not have legal standing because they were not under, they did not have negotiated rulemaking notice and comment. It's all legalese. You don't need to know all that. But what I want you to see is that right now, this administration is reigning in, is being reined in by the Supreme Court. And this is an important thing because I've seen at least 3 opinions by the Supreme Court in the last 6 months that I was disappointed with the legal reasoning behind and some of the swing votes going to the liberal bloc. And I am not, I'm a libertarian, so I'm usually hands off, less government's better government. But in this case, of these cases, I often side with the liberal bloc of the court if it means less government interaction and regulation and more autonomy and freedom for individuals. But I've seen Roberts specifically swing, and even Kavanaugh has also swung, and even Gorsuch actually swung on a decision. So we don't know truly if we have a conservative bloc of 6 or not. I think that Roberts is definitely a swing vote, and I would say not Gorsuch, but I would say Kavanaugh as well. So what's happening now is we just had a Supreme Court ruling on July the 4th, and this is a really important First Amendment case. This is talking about the state action. The fact that we even have to have a case on this is really problematic. But there has been Dr. Shiva out of Massachusetts. If you go and Google Dr. Shiva, Massachusetts federal case, you will see, you can pull up the discovery of the databases that they found. This is going back prior. Shiva was running for Republican presidential nominee in the 2020 election. So this was going back to 1819 when these things were happening. And basically a database was uncovered that all of the social media companies had access to, where local, state and local government agencies and even federal agencies, the FBI, other agencies would go in and request that either someone be shadow banned, which means that their post would no longer be shown publicly. They would be canceled just completely, or that a certain particular post, tweet, whatever, be censored and taken down. So what we have is a federal judge on the 4th of July issuing an injunction against the administration and all agencies of the, I was going to say almost Obama, of the Biden administration to not communicate with any local government actors at all. Because when you have the government agencies, the FBI, the Department of Education, the Department of Defense, Congress, when you have anybody in a government capacity that is sending requests to tech companies to take it down, posts, or censor people or shadow people, you have state action on censorship on free speech platforms. Now, there is a different situation when it comes to Section 230 immunity, which we will talk about later. That came about like in the 90s when no one even knew what the internet even was. And so these tech groups figured out a way to have Congress kind of carve them out, that they weren't responsible for the posts on their the content on their pages because they were publicly sourced, and we are the content creators, the public. So if it's a free speech platform with the public, then what is the problem? Of course, that platform can have community rules. This is how things are being censored now, through the use of these community rules. And if you don't meet our community standards, well, you can simply say that you don't want anyone to make anyone feel, upset as your community standard. Therefore, nothing that anybody says that could potentially upset somebody else, which by the way is anything, could be said. So these community standards are the way that these systems are using now to police comments they might not like internally, like Twitter. They had their entire review team. But the bottom line is the federal judge has enjoined literally federal government agencies from contacting local, from both the federal agencies at the federal level, but also the state and local actors at local races, reaching out, leveraging this database and contacting these social media companies, requesting that viewpoints, posts, and things be censored. That has now been enjoined and stopped. So that is incredible. You do not mess with a federal injunction. You don't mess with that. So, we aren't in the thick of the 2024 election cycle yet, but as we get to those stages, we need to have a fair playing field. Let the best person win, whoever he or she may be, but let's not have it skewed by the government when these people are running for government positions. This is this is a banana republic when you have the government, censoring what people can say on public platforms that they've signed up for. So that is a really great decision and has also come down just recently. And so the Supreme Court is winding down for this session. We will get some more decisions later this year. But for the right now, I think that, we've had a couple of misses, but I think for the most part, we're starting to see a concerted block of bringing back some constitutional meaning and not letting the administrative state just run crazy. Like, we'll just tell you by executive order that your loan is forgiven and your loan isn't because you already repaid it or you make too much. And that has been found to be unconstitutional, that the Congress would have to give specifically that legal authority to the administration explicitly through a law, a statute, and then the administration could take the necessary steps to figure out who they were going to forgive or not. But it has to be clearly delineated. So that is struck down. If you were a borrower who was planning on not making payments and you've already kind of gotten used to not having them for the last 3 years, time to rethink that, because that's not going to happen, and time to start putting it back into the budget again. I believe that they turned back on in September, but don't quote me on that because that was not a part of my information for today. So basically, it is a really interesting series of decisions that we got from the Supreme Court here, and I'm glad to see that we are reigning in the administrative state. The administrative state leads only one way. The road goes one way, you guys, and it goes to totalitarianism and communism, total life control of your life, of yourself, of your person, of your finances, of everything through the government state. That's known as China, and we do not want to be China, but we are on a mission. We are a lot further along than people realize, and this is going to be something that hopefully will wake people up and say, oh, the government can't just do whatever they want, and they cannot censor us. That is state action, and that should end, and that was a great decision. So thank you, Supreme Court. Until next week, you guys have a great week. Crashes and Taxes. We will be back at it every week, and I enjoy my time with you guys. Take care, everybody.